you so much, everyone, for staying with us. So it's been days of some advocacy and some rage on social media, and those who have lent their voices to the arrest of Mr. Dele Farotimi, a lawyer and rights activist. Today, we understand that the Nigerian police force in Ekiti has since filed fresh charges against the human rights lawyer. Issues of defection. All right, those are some of the pictures of the day in which the Nigerian police, officers of the Nigerian police force, we do understand that they may be, because there are those who said in the manner in which they went to his office in Lagos, arrested him and took him to Ekiti State are areas that have raised a lot of concerns. And so tonight, we're looking at different dimensions. What is the law of defamation in Nigeria, law of libel? How applicable is this? What are the implications of the offense of defamation or libel as the Nigerian Criminal Code or any of the laws in Nigeria stipulate? I'm being joined tonight by a very senior lawyer, Mr. Jiti Ogunye, who is live for us in our Lagos studio. It's good to see you, Mr. Ogunye. Thanks so much indeed for your time tonight.
It's my pleasure. Thanks for inviting me, Sean.
Thank you so much indeed. Give us an understanding, and I've seen a lot of lawyers also argue differently. There are established principles on the law of defamation and the law of libel. And I do know also that in Nigeria, our laws also recognize the offense of defamation and that of libel. But there are those who say, oh, maybe Lagos and perhaps maybe Edo State or one other state have abolished the criminal aspect of the offense of defamation or issue under the defamation law in Nigeria. But I'd like you to summarize for us and probably put to bear the argument, give us an understanding. What does the law of defamation, either as a civil defamation or criminal defamation, and as it applies to Lagos State and perhaps under the criminal code in Nigeria? Give us a brief understanding. Educate us tonight, Mr. Ogunye.
Thanks, Sean. The subject is not a woolly one. It's a matter in which a lot has been written and a lot has been said and a lot has been decided by our courts. Defamation are in two parts. You have civil defamation comprising libel, which speaks to the written word, and slander. You also have criminal defamation, otherwise called criminal libel, which is provided for by our criminal law. Before now, we all know that we have two principal criminal legislation in Nigeria: the Penal Code in the northern part of the country and the Criminal Code in the southern part of the country. And so the states in the federation, depending on which part of the country they fall, derive their criminal law principally from those two principal criminal legislations, i.e. the Penal Code and the Criminal Code. And in the Criminal Code, which is still an extant law, and which federal prosecutors and the police use when they want to charge offenses across the states, you have criminal defamation, which is provided for by Section 373 down to Section 376 or 7. Section 373 defines, and 374 defines criminal defamation. 375 provides for the penalty, 1 year or 2 years, depending on whether it's willful or the person who published that criminal defamation knows at the time or knew at the time was publishing it that it was false in every material particular. You have section 276 that deal with defaming in order to extort. That's a felony, not a misdemeanor. It's provided for there, the penalty being 7 years, being a felony. And then you have other sections that follow that defines absolute privilege and qualified privilege, depending on who is making the statement, whether it's the governor or the president or minister and so on and so forth, so they can make those statements in political circumstances, and those statements will be qualified. Now, very instructively, under those provisions, there is a defense of truth and public interest. If the statement is made to advance public interest and it is the truth, it is truthful, that offers an absolute defense. But if it is false and it is meant or calculated to injure any person, be in authority or a private individual, in his trade, in his profession, to bring him to public ridicule, whether he be living or dead, which is the distinction, whether the person is living or dead. If so, if you defame a person who is dead and think that he's dead, the Attorney General of the Federation or anybody can bring an action. But you will need the permission of the Attorney General of the Federation at the federal level to give consent to such a charge if the person is dead. That's the distinction. In civil libel, however, that is very familiar. And I've seen a lot of discussions in the social media and in politics by those who are trying to play lawyers and the court in the social media. Everybody's a lawyer now, in the social media, Facebook and everywhere, saying that, oh, criminal defamation is dead. You shouldn't be talking about criminal defamation. Civil, sue people to court and all that. It's not that easy. The legislation is there, the provision of the law is there, and you may not have the pedestal to advise a person who claims he's been injured or defamed on the course of action to take, whether he should go to court to sue the person who allegedly defamed him in civil litigation or resort to criminal defamation. If you want criminal defamation to go, you have to sanitize the law. You have to remove it. A lot of Article 19, advocates, Section 39 advocates, who are talking about a freer society, a more democratic society, a more open society, a more transparent society, particularly after we've had the FOI, Act in 2011. I've been saying that these laws and the law of sedition should be wiped out of our criminal law. Yes, there's been a lot of arguments in that regard, but insofar as those provisions are still there, please, we'll continue to have recourse to them. And those who feel injured, we're going to have recourse to them. Now, let me dilate here a little. In civil litigation on libel and defamation, the action is usually an action in personam, meaning that if an old person claims he's injured or is defamed, and he goes to court to sue, if in the course of that litigation he dies, that action is dead. I recall, for example, in the Second Republic, Chief Obafemi Awolowo of blessed memory had reason to sue the National Concord. In those days, National Concord was more or less like the paper of National Party of Nigeria, led by Alhaji Shehu Shagari, particularly when Chief MK Abiola was still in the NPN. Before he left, when he was told, he was served breakfast, in a manner of speaking, using the street lingua now, that presidency was not for sale, and he left. But before he left, his paper, the Yoruba version, Ishokan and all that, were lampoon Awolowo, calling Baba Isalegbe, Onino, all sort of things. Awolowo sued National Concord. And Awolowo died in 1987. And that action died with him. So nobody could hear that action. So if you see an old man resorting to criminal defamation as a recourse and not civil litigation, your guess may be good as mine. The person may feel that I can't spend so many years in court in civil litigation and so on and so forth. The summary here is that there is a distinction between civil libel and civil defamation and criminal defamation, otherwise known as criminal libel. And the provisions are there.
All right. For the things that Mr. Dele Farotimi was alleged to have said under criminal defamation or civil defamation, and the things that are said to have been written in the book that he published under libel, the law of libel, what is under discourse right now and in the debate that will be going to court. Now, and there are interesting dimensions to this matter, Mr. Ogunye. The court in Ekiti, we understand, had issued a bench warrant on Mr. Dele Farotimi that he should be brought before the court in Ekiti. Lawyers who have said, oh, maybe Dele Farotimi should have gone to court to stop that bench warrant. And there are those who have said, okay, in Lagos, the criminal law of Lagos State of 2011 had omitted the criminalization of defamation in Lagos. And those who have stood to debate the fact that under the Lagos laws in Lagos, as a matter of jurisdiction, you cannot criminalize defamation. But under our criminal code, there is still an establishment of the criminal perspective to criminal code. Give us an understanding, because now, if you look at the case of Dokubo Asari versus the Federal Republic of Nigeria, the Federal High Court had established that defamation or criminalizing defamation is unconstitutional. In that perspective, within that realm, well, we understand Mr. Afe Babalola has gone to the police to seek redress and seek protection of the law of whatever Mr. Dele Farotimi had written or said. What do you think exactly is going on here? Those who have argued, how would a police, according to them, abducted Dele Farotimi and took him to Ekiti? What is wrong in the action of the police in that perspective? And perhaps what is also wrong in what Afe Babalola has done or the police has done? Is there anything that you have found out in that respect?
We will have to be circumspect here, even while we are discussing this matter in the public interest, so that I can do justice to the invitation extended to me to share my thoughts with Nigerians on this subject today. And the reason why we have to be circumspect is that parties are in court now in criminal litigation. And so we shouldn't be saying things that can prejudice the rights or interests of the parties. But being a matter that is a matter of public interest, we can discuss this matter without being judgmental on the validity of the charges or the steps that have been taken and all that. Now, so I will be very nuanced in this segment of this interview. A number of things. You cited the case of Asari Dokubo and some other cases. As a matter of fact, before now in the case of Otonwako and the state, the law of sedition also provided for in the criminal code was pronounced dead. You know, you could have such case law pronouncements and all that. That will not make those provisions dead, particularly when those provisions were not specifically pronounced dead by a court action targeting those provisions in the case of judicial review. For example, when a law is passed, just like the Administration of Criminal Justice Act, and provisions of that law come up for interpretation in court, and a specific case is made to nullify those provisions or declare that those provisions are null and void and unconstitutional, such pronouncement can be made and they will be binding. But I'm not aware that these have been done in respect of these provisions in the criminal code. So they are still alive, and they can only be deleted via an invitation by perhaps the Law Reform Commission and all that would then invite the legislature to nullify these provisions or amend them out of the legislation, the criminal code. The second point is about Mr. Adele Farotimi that has been arrested in Lagos. Yes, in the case of Avomo and that has been cited, when this matter came up. Yes, Honorable Justice Ogunye in his judgment in that case had declared that the law of criminal defamation is dead in Lagos State and Edo State. And that's so because in Lagos State and Edo State, we've had a revision or reform of their pre-existing criminal code. In 2011, there were some reforms in Lagos. I think that Professor Ayo Ashenowa, former Dean of Faculty of Law, University of Lagos, headed a committee to help reform that law. And I think that the result was that criminal defamation was deleted from that law. So from 2011, that law has reenacted criminal defamation is dead. But we're not told that it's dead in Okiti State, for example. We're not told that it's dead in Ogun State. We're not told that it's dead in Ondo State and in some other states. Until those laws or those provisions are removed from their respective criminal code, they will still be resorted to, they will still be used and all that. That's the number 2 point. And in this case, the allegation of publication and circulation and defamation was located within the Ekiti State, where the complainant resides, that they bought this publication and came to, he had been defamed in the Ekiti State. So to that extent, you could say that that court in the Ekiti State could have jurisdiction. But as I said, the matter is before the court. The number 4 point, if my numbering is correct, is the issue of effecting arrest in Lagos and taking a person in a state. This has been a sore point. A number of journalists in the past were arrested either in Abuja, Lagos, elsewhere, and taken to, in the River State case of the lady who was imprisoned for some time, the behest of an ecclesiastical giant, or spiritual giant, so to speak, Lord spiritual, Lord temporal. That's, I'm playing on words right now. So it's also cited as a reference because the person was not arrested in River State, but taken to jurisdiction and successfully jailed. So we've been having this kind of thing, and it may rankle. But, there's a notorious case in criminal law, which is called the case of Patrick Ijonvens at the state. Talks about conspiracy and criminal elements or aspects of any alleged criminal offense taking place in a number of states, like straddling. If you conspire in Lagos and then you effect the conspiracy in Abuja, or you went to Ogun State to procure arms and went to the state after Ogun State or your state to also do something, any of these states will have jurisdiction to tackle the matter. All these can be, and certainly will be debated in court. But the point to note is that the matter is not as simple or as, unimportant as some people are trying to make it. Certainly, there are serious issues here. There are serious issues here. I've read Chief Adeola's letter and the allegation I have a copy of Farotimi's book, and I've not fully read it. I've read aspect of it. And they were weighty allegations. I used to think that lawyers are trained to be circumspect. We have trained tongues. That's why we're advocates. If you don't have proofs, don't make such allegations. Don't. And so at the end of the day, you will not be able to dictate to the victim which course of action to take. And in this case, just briefly, what all these things are about, there were litigations. Farotimi was involved in an aspect of that litigation. The litigation at the apex level was taken by firm for one of the parties, and I'm not sure Chief physically will be going to court. He's old. The lawyer in his chambers, our friend Oludaramola, senior advocate of Nigeria, was mentioned. So all sorts of persons were mentioned, judges and all that. The Supreme Court was particularly pilloried and condemned with very heavy words. So that's today, so that will be clear. Will be clear to those who are dancing out there. Will be clear. Multiple charges can be sustained against the person. And I'm not urging that this be done, because I'm a person who likes escalating these kind of things. For example, when you took the Supreme Court justices to the cleaners, call them names and say that they are corrupt, and you are specific and categorical. The Attorney General of the Federation, who incidentally is Chief Babalo's protégé, who became a son in his chambers, could just reach for the law of criminal contempt of the Supreme Court and charge you, independent of anything that you are saying. You better have your facts. And then it's traveled to Lagos State Judiciary, the corrupt and all that. Incidentally, the Attorney General of Lagos State, Pedro, son, who is also mentioned there, can also sustain an independent charge like that. So you see, there's a saying in Yoruba land that says that Editi o Mobalon for Banshiri. I think that proverb is in the feudal world, when an Oba will say that they should go and sever the heads of somebody for not even liking the person. Law is very important. And lawyers are the ones who understand the law better. You can forgive people in the social media who say all sorts of things. Ignorance is bliss. But if you are a party to a case, you lost a case in the court of first instance, appeal is a remedy. You just can't come out and say that, yes, do you know how many cases I've won and how many cases I've lost? Do you know how many times I've won cases in the High Court, in the Court of Appeal, and we got to the Supreme Court, and the Supreme Court will say, oh, jurisdiction, and all that. I wouldn't go out to say that, yes, they are corrupt, you won't say that. And I'm not saying that if you have your facts in the public interest, you shouldn't say that. So, as I said, truth, justification, public interest, altogether is a defense. So if you are saying the truth, you can go ahead and publish whatever you want to publish. But certainly you won't say that the person who is at the receiving end won't have recourse, either to criminal defamation.
So, Mr. Ogunye, this is, so you're saying that, yes, there is a right of every citizen to a freedom of expression, but there are limitations also to the extent of what you can say, or how much you can bear your mind if you don't have facts to what you're saying. But to conclude this conversation, Mr. Ogunye,
yes,
there are protests that are being that have come in the occasion of this issue in court, and there are mobilizing people in Ekiti, in Lagos, in London, and in Abuja for protest. This has gotten some kind of public interest. How do you think this can be handled?
Let those who want to organize protests go ahead and organize their protest. It's their right to protest. So, look, I'm a student of the protest movement. I'm no longer a student. All my life, university, I organized protests, big ones. So during the anti-military struggle, we were also there. Rights were constrained. Our movement was constrained. A lot happened. Many people were detained. People died. So we understand what that is. And for activists, quote unquote now, who say that there's a lot of things that people say. It is unlawful to be law-abiding in the state of lawlessness. People say all sorts of things. We were saying all those things then. And so people who have challenges of brushes with the law may think that what is best for them to get out of those challenges is to politicize the matter, and all that, and put pressure on state institutions and structures. That's within their right to do, because they may think that their matter is a political matter, as we've been told, and so they can take those steps. But those steps alone will not deal with the... After all, in a climb, such steps can also work. For example, some children that were tried recently, so the federal government dropped the matter like a hot potato. So if you have such references, there may be people who may think that, this kind of thing is also part of it. An injury to one is an injury to all. After all, he's an activist, and he supports what we're saying, and he condemns people too. So we should all rally around. The people may want to do that, and so they may stage a protest. But the point I'm making is that, yes, the point as I'm trying to close, subject to what you may say, is that in the field of public intellection, because we talk to a lot of people, or activism, or radical advocacy, or fighting for people's rights and all that, truth is very important for us to maintain. Don't injure anybody without cause, without reason, if you must injure people. And when you're talking or you are writing, always be circumspect. I come on television every time. You know that I have very pungent views. I'm a passionate debater, but I chew my words. I recline back. I'm a slow talker. Because I don't want to mistalk. And I know that you're talking to a lot of people by the advance in technology. Right now, I'm talking to the world. I'm not just talking to you, Sheil. So what we say matters. It has consequences. I can see a lot of people, they derive validation from this because they are also reckless themselves. I mean, look at what is going on in the social media in Nigeria. Just look at it. So that even the best advocates of right to freedom of expression will hesitate and wonder whether this thing that is going on is it. I mean, people make statements and say that the judiciary is gone, there is no justice there. So a social media influencer is your recourse if you want to get justice. So if you scrap the judiciary, what do you think will happen in our society? So is that what's going to happen?
Ogunye, we need to close quickly. And there are those who would think that the fresh charges filed against Farotimi are just maybe tactics to prolong his days behind the bars, as is being kept until his bail hearing is being taken in the court. And also there are those who think that whatever happened from taking him from Lagos to Ekiti State or putting him behind bar is just using a more privileged power to oppress Farotimi. Is that what it looks like? Or is that what the case is?
You know, there are people like us who in any conflict have the natural instinct or ideological instinct or political instinct to side with the underdog or to side with the person that they perceive is the victim. This current debacle is a sorry one because it's like a lawyer who is representing a client shouldn't be so worked up as to be claiming the injustice that has been done to his client, assuming that that's what it is. Because that's the story. There are families that are contending over land. Lagos family have always been contending over land. They've always been fighting over land. Very litigious. Okay? And so you are a lawyer that is hired to do your job. If you do your job and you feel that you'll be cheated, you will pursue that matter. But since this is the path that is chosen, there are consequences to everything that we do or we do not do.
All right.
The case,
all right,
since in court, I've told you, I cannot discuss the nitty-gritty of it. I cannot say this is why they are doing this. This is why they are doing that. I won't go that far. All I have told us this evening is that these provisions are in the law to the unenlightened and the ignorant and the rabble-rousing who are saying that no, all these people there is there. The fact that you are not ignorantia facti
we've got to go. Yeah.
Ignorantia jure.
We've got to go, Mr. Ogunye.
Excusat.
Yeah.
Yes, I'm giving you that because I know that you soon be an initiate of the law fraternity.
We've got to go. But quickly, is criminal libel a valid law in Ekiti State? Just a state one. Is criminal libel a valid law in Lagos State?
It is not.
Or is libel criminal in Lagos State?
It's not. It's not because they've sanitized the law. They reformed the law in those two states.
In Ekiti State
and Edo State.
All right.
And it is good. But in Ekiti State, I don't know what the status is. But I reckon that charging against the Criminal Code Act, Criminal Code, the federal legislation that the police is using. And they explain that they can, because of Osao and the Federal Republic of Nigeria, the police can continue to, outside the Ministry of Justice, continue to charge everybody and all that, which is part of what should be harmonized everywhere, anyway, because we have a lot of charge-preferring authorities and agencies in Nigeria. It's like a medley, if you ask.
Thank you, Mr. Ogunye, for your time tonight.
Yes,
I appreciate it. Mr. Jiti.